Okay, so hello and welcome to everyone joining us today for our contentious clinic. This month, the topic is on the complex world of trusts. My colleague Hannah Coton-Smith and I will be running through the common issues we see with trusts, mentioning cases that we have seen in the news and hypothetical cases we've created from our own experiences over the years. We hope in doing so, we add a bit of interest and context. The webinar today is expected to last around 30 minutes and will cover an overview of wrong advice, wrong product, wrong drafting, wrong trustees, and what can go wrong when everything else goes right. As my colleague Hannah pointed out earlier, it doesn't sound like the most positive webinar, but we're hoping it will be useful. As I'm sure you can imagine, there is a lot to cover in trusts, and so we will just briefly be going over examples of each of the issues noted. Each section is expected to last around 5 minutes, bringing us nicely to a close at around the half-hour mark. I should say at this point, if anyone does wish to learn any more about the issues we raised today, further information can be found within the IDRN, which is a free network full of guides and resources and helpful tips that we've prepared and update regularly. If you've not signed up and wish to have further details on this, more information can be found on our website. We also regularly post details on our LinkedIn page, so do follow us there also. And so to begin. To add flavour to today's webinar, we will be talking about a hypothetical family we've created called the Claimers. I couldn't help myself, I'm sorry. Mr. and Mrs. Claimer had been married a number of years and together had 3 children in our scenario. 2 of the children were born close together when Mr. and Mrs. Claimer were in their early 20s. The third, who we'll call a surprise child, was born around 20 years later when Mr. and Mrs. Claimer were in their early 40s. Jumping forward in time around 30 years, Mr. Claimer sadly died, and Mrs. Claimer is in her early 70s. Mrs. Claimer is mentally still doing well, so no issues there, but physically suffering with expected ailments given her age. Mr. and Mrs. Claimer's eldest children are now in their early 50s. They each have their own properties and families and have secure financial futures, having worked in successful careers. Mr. and Mrs. Claimer's youngest child is now in their early 30s. They are at the start of their career and are in rented accommodation. They don't have a family. Now the scene's been set, let us begin. We first cover the issues that can arise when the wrong advice is given. I therefore now pass to my colleague Hannah to provide a wrong advice scenario for the claimers.
Okay, so in this situation, both Mr. and Mrs. Claimer are very much alive. They received a leaflet through the door from a company stating that they could help them keep their money in the family and effectively protect their assets from care home fees and inheritance tax. As Cara said, Mr. and Mrs. Claimer had worked hard all their lives and they thought this was important. So they contacted the company, had an initial meeting, and the couple decided to go ahead and put their property into trust. What Mr. and Mrs. Claimer weren't advised is that ultimately they would lose control of the property, having signed it over into the control of the trustees, none of whom they knew, and in turn, they didn't know the couple. Mr. and Mrs. Claimer didn't really have to think much of it until Mr. Claimer had to go into a care home, and Mrs. Claimer decided that she wanted to downsize as a result of this. When Mrs. Claimer went to the conveyancer to instruct them to sell the property, she was told that she couldn't, as obviously the property wasn't in her name. Unfortunately, the couple had to fund all of Mr. Claimer's care home fees, as the local authority deemed the gift of the property into trust a deliberate deprivation of assets. To add further insult to injury, in this situation at least, Mr. and Mrs. Claimer both died within the 7-year period of the transfer of the property into the trust, which meant the value obviously was still taken into account for inheritance tax purposes. So, in summary, whilst putting their property into trust seemed like a sensible idea at the time, arguably the couple were not given the right advice, or indeed sufficient advice, to enable them to fully consider their position and make the best decision for them. Had they been aware of the implications, perhaps they'd have thought twice about it.
Thank you, Hannah. Now, while that scenario may seem far-fetched, it is unfortunately very common. An example of this issue in everyday life can be seen from the many cases that have been in the press surrounding the universal wealth scandal. In December 2018, Stephen Long, formerly of the company Universal Wealth, was jailed for 8 months for failing to provide details to the High Court when requested as to the whereabouts of over £25 million worth of assets that the company had acquired through a trust scheme. The scheme, very similar to Hannah's scenario, was one which was sold up and down the country and encouraged those approaching retirement and those not quite there to transfer their property, being the main asset, amongst other assets, into a trust with Universal Wealth. The idea behind the trust was that those signing up would ring fence their property and larger investments from inheritance tax or care home fees in the future. Despite a potentially sound premise, the wrong advice was given. People were not made aware that they would no longer own their homes, nor that they would have no control over any of the assets placed into the trust. Amongst many others, the universal wealth scandal has caused at least 2 very problematic issues. The first was that the company, which appeared to have been anything but trustworthy, took control of the assets in question. And the second was that by taking control of assets, which are inherently known to increase in value, any future disposal of those assets would result in a large capital gains tax bill. Unfortunately, with the appointment of trustees who appear to have been using people's assets to prop up their own financial responsibilities, including those of their business, further issues arose when it came to actually locating the assets. As I said earlier, £25 million worth of assets went missing, meaning those savings and investments that many had spent their life acquiring with a view to using Universal Wealth scheme to ring fence the money for their family's future benefit were simply lost. As to the properties people were living in, well, the title of those properties were transferred into Universal Wealth's name. And so when later deciding to sell a property to downsize or relocate, for example, all had lost the benefit of capital gains tax relief, and many were unable to go through with any property transaction as the owners couldn't be located to sign the required paperwork. While it appears both civil and criminal cases are ongoing, Stephen Long does pop up again every so often seeking to sell the same product under a different name. This most recently occurred in early 2021. Caution must always therefore be given when advising clients on such schemes. Essentially, does it sound too good to be true? Well, then it probably is. While not possible in every case, IDR law have been successful with recovering assets and properties into individuals' names and circumventing the otherwise significant tax payments that would be due. More information can be found on our website and within the IDRN, including a video from Mr. Wade, a former Universal Wealth customer who we have helped. So up next, we discuss what can happen if you have the wrong product. Imagine this scenario for Mr. and Mrs. Claimer, back to our hypothetical family. In this situation, Mr. Claimer has only recently died, and as a reminder, their 2 eldest children have their own properties and families. In this scenario, however, let us say that Mrs. Claimer's eldest child has moved in to live with her, as Mrs. Claimer has been lonely since her husband's passing, something very usual. And her youngest child in this scenario is in supported living and in receipt of benefits. Mrs. Claimer wishes for her children to inherit equally, but has 2 aims in mind. Number 1, she would like to offer any of her children the right to live in her property during their lifetime, should they wish. And number 2, that the inheritance due to her youngest child should be dealt with in such a way as to limit the effect it will have on their benefits and the associated support they receive as a result of those benefits. In this scenario, Mrs. Claimer's property is worth, let's say, about £150,000, and she has some minor cash assets worth around £5,000 and a funeral plan. Mrs. Claimer instructs someone to write her will, and the advice given is to place her entire residuary estate into a discretionary trust with the 3 children as beneficiaries. She's concerned to ensure that there are no issues with the trustees, and so she appoints professionals. Mrs. Claimer is assured that her estate can still be split 3 ways and that the option for the children to live in the property will still remain. She is also assured that there is added protection for her eldest children in case of bankruptcy or divorce, saying the trust will be outside the reach of the court, and is told that the trust equally protects the youngest child's benefits. As is relatively usual practice, Mrs. Claimer is told to prepare a letter of wishes, That letter sets out her desire for any of her children to have the opportunity to remain living in the property if they wish, as well as her desire for her estate to be split equally between the children. Okay, so fast forward a few years and Mrs. Claim has now died. Her eldest is still living in the property and asks about the will. They are sent a copy of the will and the letter of wishes by the trustees, who take no independent advice before doing so. Having seen the letter of wishes, surprise, surprise, the elderly child decides to move his whole family into the property and in turn rents their own property for a revenue. The other children are understandably concerned by this, as they want their inheritance and had understood that their parents had always wanted them to inherit equally. Now, while this may be an extreme example, it is one that shows it is vital to have the correct product in place and also the correct advice given. This scenario is one where clearly a further discussion needed to take place with Mrs. Claimer to fully understand her wishes. Given the relatively small value of the estate, it's clearly not possible for one child to stay living in the property with the others getting cash assets of an equivalent value. And so Mrs. Claimer would need to have been told about the conflict in her wishes and asked about what her favoured outcome would be. Was it more important for her that her children had the opportunity to live in the property, meaning it unlikely that they would all inherit equally or even at all? Or was it more important that the estate was split equally? If Mrs. Claimer had a genuine desire to allow her eldest child the opportunity to live in the property for their lifetime, then a life interest trust would likely have been more suitable. Equally, if Mrs. Claimer had only wished for her eldest child to remain in the property for a short while to sort out their own living arrangements, had such arrangements been necessary, then a time-limited and conditional right to reside could have been included. In both scenarios, the estate could pass equally, Sorry, bit of a coughing fit there. Sorry, where was I? So in both scenarios, yes. So it could have passed equally to her children and their respective families, or they could have had a time-limited conditional right to reside, or a life interest if that was more appropriate. Equally, though, the discretionary trust could have been the most sensible product, particularly had the trustees not sent the letter of wishes to the beneficiary. In that circumstance, they could have considered the financial implications of all of the beneficiaries as a whole and made a decision as trustees on how to proceed. Now, over the years, we have seen a number of differing wills created as a result of this particular family's circumstances, which are not unusual. Clearly, it won't be a one-size-fits-all scenario. The individual circumstances for each family and the express wishes of the testator are all going to be relevant. As practitioners, though, care needs to be taken to ensure that the most appropriate course of action is recommended. It is not unheard of for companies to push for trust when the trust simply isn't the right product for the circumstances, or to push for two or more trusts within the same will solely for financial gain. While an unregulated area of law at this time, care does still need to be taken when considering drafting wills. A failure to do so may result in a professional negligence claim being made against the will writer by both the actual beneficiaries, as well as those beneficiaries who have potentially missed out. It can therefore be a costly mistake to make. It also results in potential claims against an estate, of which IDR law can assist with the resolution of. However, that's clearly not in the best interest of the testator and their respective families. An issue that has arisen in this sort of area in the real world is the case that Hannah will now discuss of Kaur and Singh.
Thank you. So it's a very recent case. As you can see, Mr. and Mrs. Kaur were married for 66 years, so a long marriage. Mr. Kaur sadly died in August 2021. At the time of Mr. Kaur's death, they had 6 children, 2 boys and 4 girls. Mrs. Kaur was quite elderly by this point, and she was and had been financially dependent on Mr. Kaur throughout the marriage. The value of the estate was approximately 1.2 million, and Mr. Kaur's will left everything equally between his sons. He effectively disinherited Mrs. Kaur and his 4 daughters, sorry. Understandably, Mrs. Kaur brought a 75 Act claim against the estate, and she was awarded half so half of 1.2 million. The reason why we've included this one in particular is that it could have been avoided if Mr. Core, whilst we appreciate he had testamentary freedom, if he had perhaps been given advice about the inclusion of a life interest trust in his will, whereby Mrs. Core would have been able to live in the property, and on her death it could have gone to his intended beneficiaries. Also, if the parties had engaged in discussions post Mr. Core's death, they could have discussed a potential deed of variation, which would have likely resolved the situation, and they could have also undertaken inheritance tax planning to utilise the spousal exemptions, which obviously didn't come into effect on Mr. Core's original will. So they could have avoided the expense of litigation and got to the outcome really that was achieved in any event by going through the court. So we can now look at a situation, moving on to our wrong drafting, a situation where the actual drafting of the will and other associated testamentary documents has meant that the outcome wasn't quite as the deceased had intended. So we'll go back to Mr. and Mrs. Claimer. They are both still alive, and they decided quite wisely not to put their property into trust at that stage. But when they were taking advice about that, they did speak to their solicitor about putting a will trust in place to ensure their estates passed down to their respective children. So just to mix this up, in this scenario, Mr. Claimer had 2 children from his first marriage, and Mrs. Claimer had 1 child from a previous relationship there, so they had different sets of children, which obviously a life interest would be helpful. However, whilst in the meeting with their solicitors, they went ahead and got the will trusts in place. The solicitor drafted the wills with life interest trust clauses on first death and the residue passing to the survivor. Mr. and Mrs. Claimer were happy with the wills, and they went to the solicitors to get them all signed. In the meeting, the solicitor forgot to print off the severance of tenancy, which does happen, and said that they would post it on to Mr. and Mrs. Claimer to sign at home. Unfortunately, in this scenario, the solicitor forgets and closes their file. Fast forward, Mr. Claimer sadly dies, and it's only at this point that they realise the tenancy was not severed. So whilst the trusts and the wills had been drafted correctly and in line with Mr. and Mrs. Claimer's wishes and intentions, the property simply passes by survivorship. Had the tenancy been severed and the life interest trust come into effect, the claimers' intention was to pass their respective shares of the property on to their respective children. Unfortunately, as Mr. Claimer died first and the tenancy remained unsevered, as I said, the property passed to Mrs. Claimer by survivorship, which then meant on her death, it would fall to be distributed under her will, so solely to her child and not to Mr. Claimer's. So whilst Mr. and Mrs. Claimer's situation in this particular case is one that could be rectified posthumously by way of an agreement between the relevant parties, Cara will now outline a case which deals with the court's approach when dealing with a badly constructed will.
Thank you, Hannah. As Hannah said, an interesting and relatively recent case setting out the importance of careful drafting is that of Goddard and Hunter. Although not hotly contested, an application was necessary to the court to enable the interpretation of some difficult, clumsy drafting that had taken place. Now, this matter involved the will of Harold John Goddard, which was signed in February 2008, and specifically the issue related to Clause 5. Clause 5 was headed right of residue in house. The clause contains some standard right to reside or quasi-life interest conditions, which I've put up on the slide. Essentially, they gave Mrs. Goddard the right to live in the property, provided certain conditions were met, and put on her certain obligations, such as insuring the property and keeping it in good repair. Nothing specifically unusual about this. Equally, there was nothing specifically unusual about clauses 5C and 5D either. The issue arose, though, over clause 5E, which is also on the slide I've just put up and I have highlighted in italics. As you can see, clause 5E states that at the resident's request, my trustees may sell the property and buy another to be held on the same terms as the property. Any surplus arising from the sale and purchase forms part of the residue of my estate. Now, while not up on the screen, clause 6 provided that for the surplus of any sale of the property, this would pass 95% to the deceased children from a previous relationship, and they were the first 3 defendants, and 5% to the deceased grandchild, of which there was only one, the 4th defendant, again from a previous relationship. The difficulties the party faced was that the property in question was not solely owned by the deceased. In fact, it was held as tenants in common between the deceased and Mrs. Goddard. The parties therefore questioned whether any future property must also be purchased, with Mrs. Goddard contributing a 50% share and the trust contributing the remaining 50% share, or whether, if Mrs. Goddard was downsizing, as was the case in this matter, could she continue to have the benefit of all of the proceeds of sale from the deceased share of the original property and contribute herself a smaller amount or none at all. The court found that any future property must also be purchased 50% by Mrs. Goddard and 50% from the trust. In doing so, it made it very clear that if there was to have been a different interpretation of the clause, the will would have needed to have been prepared with clear drafting and instructions. Now, in this matter, the court relied heavily on the attendance notes from the will file to assist with its interpretation of the deceased intentions, as well as applying the plain reading and natural meaning of the words. Accordingly, therefore, care should always be taken to both taking and keeping detailed attendance notes. But it's also really important to stress test the desired outcomes with the test data to make sure you are clear on their instructions and able to draft a will which reflects those instructions. So moving on now to our next heading, which is wrong trustees. I recently wrote an article on LinkedIn, which you may have seen, which is also on our IDRN network, albeit with different characters involved in relation to this particular topic. But for today's discussion, I will keep it with Mr. and Mrs. Claimer's family. So here's the scenario. In this situation, Mr. Claimer, for me, has still died, and Mrs. Claimer has left her estate in discretionary trust for her children. There's a detailed letter of wishes setting out how she wishes for her estate to be distributed. Essentially, she asked for lifetime giving to be equalised and then for everything else to be split equally. The advice here was right. It was not possible to give a fixed sum in the will to equalise lifetime giving, as the values of those respective investments changed over time, and also because Mrs. Claimer continued to make distributions over the course of her lifetime. The product was right. It gave the trustees the flexibility required to enable that lifetime giving to be equalised and allowed the trustees to take into consideration any personal circumstances of the beneficiaries so as to protect the estate's assets. There were no drafting errors. The will was very clearly written and the trust effective. The only problem in this scenario was the trustees. Mrs. Claimer was so confident in her children doing the right thing that she appointed her 2 eldest children as trustees. Unfortunately for Mrs. Claimer's youngest child, they disregarded the letter of wishes and distributed the estate entirely to themselves. Trustees are so named because of the trust and confidence that is placed in them in these situations. A poorly selected trustee can cause insurmountable problems, from trustee disputes through to fraudulent activities. While understandably frustrating for many beneficiaries involved, a discretionary trust does leave the trustees with absolute discretion. Of course, there are duties and obligations that they must comply with, and claims that they or the estate must face if they don't act appropriately. But those potential claims may not always be available and may leave many facing the unexpected loss of an inheritance, as well as the grief of losing a parent. Unfortunately, this is not an uncommon situation. Sibling rivalry is rife in estate disputes, and perceived or actual slights when the parties were younger, and or perceived or actual favoritism by a parent, all can result in emotive disputes, or as in this scenario, a potential for a child trustee to feel they better understand their parents' wishes when compared to the actual letter of wishes that was prepared. Now I pass over to Hannah for some real life examples.
So sadly, there were quite a few examples of executors and trustees not undertaking their duties correctly and actually being held to account by the court. So rather than just focus on one, I thought I'd give an overview of a couple. So the first one, Gibbs and Loveday. Anita Border sadly died in 2015, and she appointed her neighbour, David Loveday, as an executor of her will. Her estate was worth about £240,000, and within that under her will, she left legacies of £110,000 to two of her good friends, Parminder and Emma. Emma received her legacy, no problem. Conveniently, she was David Loveday's partner, but unfortunately, Parminder didn't receive her share. So, in order to try and get what she was entitled to, Parminder took the matter to the High Court to try and remove David as the executor. During these proceedings, it became apparent that David had simply frittered the money away. He'd spent it on, as I've set out in the slide, holidays, an Audi, settling his debts and general living costs. In this case, he was actually sent to prison for 3 years. He pleaded guilty to fraud by abuse of position. And as I've said, the judge said that David showed absolutely no remorse. Sadly, in this situation, whilst Parminder didn't get her legacy, which her friend had left her, she also had to remortgage her house to pay the significant legal fees that a 4-year litigation fight to get to this position. The second case that I had a look at was Totton. So Hazel Totton died in 2019. She left a will appointing her son Mark as the executor. In the will, she left 3 legacies of £10,000, and the residue was divided as to 1/2 share for Mark, so the executor, the other half being divided between her grandchildren, Holly and Daniel, who were Mark's niece and nephew. The estate itself was valued, as I've said, about £550,000, and the main asset was Hazel's property, which Mark sold as executor in April 2020. Holly and Daniel wanted to terminate the trust and distribute the assets equally between them. They wrote to their uncle initially, obviously as executor, via solicitors to ask him for estate information, to get an understanding about what was going on, and he simply didn't reply. In order to progress matters, Holly and Daniel then brought a claim under CPR 64.2. They asked for a full inventory of the estate, they requested that it be distributed, and they also asked for a freezing order to stop Mark from making any further distributions because they didn't know what was going on with the estate. The order was granted, and under the terms of the order, Mark had to inform Holly and Daniel's solicitors within a week of the order of the assets within the estate. Mark, unsurprisingly, did not comply, and as I've explained, there was a penal notice attached to the order, and he was found to be in contempt of court. He was actually sentenced to 4 months in prison. He apologised profusely to the claimants and to the court, and he simply admitted that he'd been unable to deal with the situation and had just tried to ignore it, really. So that's unfortunate. He could have looked at dealing with that a different way, got solicitors involved, but so that situation. And finally, we've got the estate of Richard Walker, which is, I think, quite a recent one. It's been in the news. It's an awful case. Catherine Walker was the mum of Richard Walker, who was a soldier who died whilst on duty in Afghanistan. His estate was worth £455,000, and he left a will, obviously appointing Catherine Walker his mum and setting out that his estate should go to an intended beneficiary who wasn't his mum. Instead of distributing the estate, Catherine spent all the money. She is said to have bought caravans, private number plates, and horse boxes. And whilst no one can take away from the tragic circumstances of having lost her son put her in a position of trust, which ultimately she breached. And she pleaded guilty to fraud by abuse of a position of trust and was also sentenced to prison, but for 3 years, 4 months.
Thank you, Hannah. It is really, there's a lot of issues with trustees, and so it is really important that you appoint the right one. That brings us to the end of the 4 wrongs. Now it brings us to the, well, what if you did everything right? Is there anything else? Is that a nice tick box? Are we happy, or can something else go wrong? So the short answer is, unfortunately, there is a lot more that can still go wrong. As we've touched upon briefly today, there are many other issues. Some of those are the following, which I've set out on the next slide, which is bankruptcy, divorce proceedings, inheritance claims, and tax issues. No doubt to everyone's relief, we don't plan to discuss tax today, too vast an issue to do even a 5-minute overview. Given the time, I also plan to only briefly discuss the remaining issues by noting that all of these claims can and do involve courts that are willing to attack any trust made in a will, where it is clear that a person will be in receipt of funds in due course. So, for example, with divorce proceedings, improperly hiding assets from a divorcing spouse only to then reach settlement can leave the door open for their ex-spouse to bring a further claim in the future. As to inheritance claims, a settlement achieved under the 1975 Act changes the will or the intestacy rules to reflect the settlement achieved. It also takes effect from the date of the deceased's death. Therefore, any trust created by the will is essentially irrelevant. It will not protect from this type of claim.